Lawyers reveal the most damning evidence never seen in court. Why? Story 1. I am not a prosecutor myself, but here's something that happened to my wife's mother during her divorce proceedings. While they were going through the divorce, she opened a letter that had been addressed to her husband. Inside, she discovered that he was secretly hiding a substantial amount of money, more than she ever imagined. Unfortunately, because she had opened a letter that wasn't addressed to her, this piece of evidence couldn't be submitted in court. Comment 1. In the United Kingdom, that absolutely could have been used as evidence, so it puzzles me why it wasn't utilized in this case. We don't have the rather strange legal system they have in the United States, where evidence that was obtained through illegal means is somehow treated as though it magically doesn't exist or isn't relevant. It makes much more sense that evidence should still count toward determining the facts of a case, even if the person who obtained it faces punishment separately for how they acquired it, and in this specific situation, it wouldn't even be considered a crime here. It's not a criminal offense in the United Kingdom to open someone else's mail like it is in the United States. In the UK, it's only considered an offense if it can be proven that the person acted without a reasonable excuse and with the specific intent to cause harm to the rightful recipient of the mail. In this case, opening the letter out of concern that her husband was concealing financial assets during divorce proceedings would likely qualify as a reasonable excuse. It would be a valid defense against any allegations related to opening the letter. Comment 2. Just to clarify for those unfamiliar with United States law, the exclusionary rule and the related fruit of the poisonous tree doctrine don't imply that illegally obtained evidence isn't relevant to a case. Rather, the purpose of excluding the evidence is to punish or deter illegal investigative methods. The Fourth Amendment, which protects against unreasonable searches and seizures, is a cornerstone of American constitutional law. Because of this, evidence obtained illegally cannot be used in court. This serves as a powerful deterrent. No law enforcement officer wants to risk losing a significant case because they cut corners or broke the law during their investigation. That said, it's important to know there are exceptions to the exclusionary rule. For example, the rule generally applies only in criminal trials, not in civil cases such as divorce proceedings. Additionally, if a police officer acts in good faith, the evidence might still be allowed. In practice, the exclusionary rule is more about discouraging misconduct by law enforcement rather than simply about protecting privacy, though it does both. Comment 3. I'm really glad you mentioned that there are exceptions to the exclusionary rule. I'm not completely sure about every detail, since I've never dealt with it directly, but I've heard that in some cases, if the prosecution can convince the judge that the evidence would have inevitably been discovered through legal means, it can be deemed admissible in court. Comment 4. Honestly, it doesn't seem bizarre to me at all. If you allow evidence obtained illegally to be used freely, it means people can break the law and still profit from it. The person doing the illegal thing might end up with a massive windfall, possibly millions of dollars, while facing minimal punishment for their misconduct, such as simply opening someone's mail or accessing their private social media. That kind of loophole doesn't deter anyone from engaging in spying or snooping. It might actually encourage more people to behave in this sneaky, underhanded way. Comment 5. Just to reiterate what others have said, under the circumstances described by the original poster, this wouldn't even be a crime in the United Kingdom. For it to qualify as an offense here, the prosecution would need to prove not only that the person lacked a reasonable excuse for opening the letter, but also that they specifically intended to cause harm or detriment to the other party. In this case, opening the letter to uncover hidden assets during a divorce would likely qualify as a reasonable excuse, meaning no crime was committed by opening it. Comment 6. That sounds like complete nonsense made up by someone who's watched far too many American courtroom dramas on television. You said you're in the United Kingdom, where we don't have laws like that regarding exclusion of evidence. This kind of evidence absolutely could have been presented in a divorce case in the UK. Furthermore, it's highly unlikely that opening that letter would be considered an offense, if it was done with the suspicion that the husband was hiding financial assets. It really feels like parts of this story were either exaggerated or fabricated to make it sound more dramatic. Story 2. Here's another strange tale. My bicycle was stolen, but then returned mysteriously just 3 days later. When it came back, it was covered in blood, no exaggeration, and there were several full, crystal-clear fingerprints visible on it. Honestly, I couldn't believe it when I saw the mess. Naturally, I called the police immediately. But when they investigated, they told me they couldn't run the fingerprints. Why? Because the person who had taken my bike wasn't some random stranger. They were another tenant who lived in my building. Since the bike had been taken from our shared building premises, they said that changed everything legally. Comment 1. You're absolutely right to be confused. However, when the police spoke to me, they actually did offer me the option to press charges. That said, they explicitly warned me that if I chose to do so, the fingerprints wouldn't be allowed as evidence in court. In the end, I decided not to pursue charges, exactly because of those legal technicalities. It just didn't seem worth the hassle under those circumstances. Instead, I took a more practical approach and asked my landlord to change the lock on the shared garage. Naturally, I made sure that the person who took my bike didn't receive a key to the new lock. Comment 2. Honestly, this case serves as a perfect example of something people often forget. You should never rely solely on legal advice given by police officers. They told you the fingerprints would be inadmissible in court, but were they actually right? Maybe. Or maybe not. The truth is, many police officers aren't experts in legal technicalities when it comes to court proceedings. Their main focus is law enforcement, not courtroom strategy. If you're ever in a legal situation, it's always smart to consult an attorney, rather than depending on the cop's interpretation of admissibility rules. Comment 3. Someone here should really open up the Indian Evidence Act and read through its details regarding fingerprint evidence. It's quite clear about this matter. Under Section 45 of that Act, fingerprint evidence is absolutely admissible in court. The law even states that an independent expert, someone completely uninvolved in the case, must be brought in to assist the court by examining whether the fingerprint evidence is relevant and accurate in connection with the case. Comment 4. Let's try looking at this from the police officer's perspective. From their point of view, they had no concrete way to prove that the bike was stolen beyond your own statement. Yes, there were bloody fingerprints on the bike, but unless there was an eyewitness or a suspect caught in the act, they probably didn't feel they had enough solid evidence to classify it as a crime. Believe it or not, simply having blood on an object isn't automatically proof that a crime occurred. They might have seen it as more of a civil or neighbor dispute, especially since the property involved wasn't removed from a public place, but from a shared building area where both you and the person had access. That probably played a big role in how they handled it. Story 3. When I was 19 years old, something happened that I'll never forget. My cousin, who was 18 at the time, got arrested and accused of committing a terrible crime against his ex-girlfriend. This isn't one of those cases where people claim false accusations. She had definitely been assaulted. There was no question about that. However, the timeline of her accusation didn't add up with where we actually were. At the time the alleged assault was said to have occurred, my cousin and I were at home, playing Halo 2 on the Xbox. I was really into recording gameplay footage back then, because I had just started learning about capture cards and video editing. I was using an all-in-wonder capture card, which allowed me to record our gaming session. To record my own voice chat, I had to use a second microphone setup. It was a real hassle to synchronize everything back in those days, nothing like how easy it is now, but I had managed to capture the entire gameplay session, including the timestamps. When my cousin was accused, I gave his defense lawyer the video recordings, complete with the timestamps showing we were playing Halo 2 at the exact time the incident supposedly happened. Despite this, when the trial started, I wasn't allowed to testify. Even worse, the court ruled that the video evidence wasn't admissible. A result? A hung jury. No verdict. Then came the second trial with a different judge presiding. This time, the judge allowed the video evidence to be submitted. In court, I demonstrated exactly how I had recorded the video, how the timestamps were embedded, and how everything matched up. I also explained how the video capture technology worked, since it was still extremely new back then, and not widely known. Thanks to that evidence, my cousin's defense attorney was able to strongly argue for reasonable doubt. And in the end, my cousin was found not guilty, but the story didn't end there. After the trial, the woman filed for child support, claiming that my cousin was the father of her baby. A paternity test was ordered, and it revealed that he wasn't the father. Then came an even more shocking twist. Her father was arrested and later convicted of harming her in a deeply disturbing case. He initially received the death penalty, which was later reduced to a life sentence. After another appeal, his sentence was reduced yet again, to just 12 years in prison. According to records, he's scheduled for release in March. Comment 1. I work as a prosecutor, and your story reminded me of a case I handled some time ago. A vigilante from another state brought us a case that had been building up for a while. This vigilante had been pretending to be an underage girl online to lure potential predators. One day, a man approached this vigilante, who he believed to be a minor, and began sending highly inappropriate messages and explicit pictures. The evidence was crystal clear. The problem? During their chats, the vigilante had stated an age that was technically 1 year above the minimum required under our state's specific law for online exploitation cases. Even though the vigilante's claimed age was still quite young, it was just outside the limit necessary to prosecute under the statute we were working with. As a result, there was no legal way to pursue the case. No workaround, no loophole, nothing could fix it. We had to let it go, even though the evidence showed clear intent. Story 4. I'm a lawyer, though I don't work as a prosecutor. However, I frequently eat lunch and chat with other attorneys, and through those conversations, I've heard many surprising tales. Here's one that stuck with me. In our town, there was a tragic case involving the death of a young college student. She was found deceased under deeply suspicious circumstances, and despite a lengthy investigation, the case eventually went cold. Sadly, what happened next was all too familiar. The police, under pressure to solve the case, arrested a black man who worked at the apartment complex where the girl had lived. It seemed like a textbook example of authorities zeroing in on the most convenient suspect. The man went through 2 trials. The first ended with a hung jury, meaning the jurors couldn't agree on a verdict. The second trial resulted in a mistrial for reasons that weren't made fully public. While he was waiting for a third trial, something completely unexpected happened. Police were serving an arrest warrant at the home of a completely unrelated individual, someone who had no known connection to the case. During the search of this unrelated person's home, officers discovered something chilling: an entire shrine dedicated to the murdered girl. This wasn't a family member or a former friend. This was a total stranger who had filled his home with pictures and other items related to her. It was deeply disturbing. However, despite the eerie discovery, the police couldn't legally use that evidence to charge the man with the crime. They had no direct evidence linking him to the murder, just the creepy shrine. Meanwhile, the case against the original suspect collapsed and his charges were dropped. In the end, no one was ever convicted for the girl's death. Comment 1. Wait a second. If the police stumbled upon this bizarre shrine while legally executing a warrant at that home, wouldn't that be enough to justify further investigation or even a full search of the property? After all, they saw it lawfully, right? I'm not a lawyer myself, but I did take a few political science courses in college, and that seems like something they could have acted on. Comment 2. Not the original poster here, but you're partially right. In legal terms, this situation might fall under the plain view doctrine. This legal principle allows police officers to seize evidence without a warrant if it's clearly visible during a lawful search for something else. In this case, it sounds like they could have seized the shrine items based on that doctrine. However, even though they could seize those items, they wouldn't automatically have the right to search the rest of the home. They would likely have to freeze the scene and then apply for a separate search warrant using the shrine as probable cause, Honestly, it does seem strange that they didn't take it further. My guess? There's more to the story that we're not hearing here. Maybe they tried to get a new warrant, but a judge denied it. Or maybe they did search the house, but found nothing else suspicious, leaving only the creepy shrine as evidence. Comment 3. Even if they could seize the shrine, it would still only serve as circumstantial evidence at best. Sure, it would prove that this man had an unhealthy obsession with the victim, but that alone wouldn't prove he committed the crime. It's not unheard of for people to become obsessed with high-profile murder cases or public tragedies. There are plenty of strange individuals who build shrines to celebrities or murder victims, simply because they feel some emotional connection or fascination with the story. Unfortunately, just because someone has a bizarre fixation doesn't mean you can convict them of murder. Prosecutors need hard evidence, not just unsettling behavior. Comment 4. As unsettling as this story is, people need to understand that having a weird shrine doesn't equal proof of guilt. There have been many cases where individuals became obsessed with murder victims, building elaborate displays, keeping newspaper clippings, or writing personal tributes to them. It's disturbing, but not necessarily criminal. For example, there were cases involving a shopping mall Santa obsessed with a high-profile child victim, and others where ex-boyfriends or acquaintances built shrines to deceased women they had known. That said, I can't help but agree. It seems like the police should have at least followed up more thoroughly on this guy. Story 5. I'm not a prosecutor myself, but I vividly remember reading about a troubling case involving a black man. Let's call him Joe, who had been arrested and convicted for a crime he insisted he didn't commit. He was accused of taking someone's life, and he ended up spending many years behind bars. Throughout his time in prison, Joe never stopped claiming his innocence. Eventually, his case caught the attention of investigators and advocates who specialize in wrongful convictions. They began digging into the original trial, and what they found was shocking. First, they discovered that much of the eyewitness testimony presented at the trial was extremely questionable. Several of the witnesses later admitted that they hadn't been in a position to clearly see what had happened. Some were simply too far away, while others admitted that their view had been obstructed. This raised immediate concerns about the reliability of the original verdict. Worse yet, the investigators found numerous mistakes in how the police department had handled the case. From procedural missteps to sloppy evidence collection, these errors called into question much of the physical evidence that had been used against Joe in the first trial. At this point, the investigators were confident they had enough proof to convince a court that Joe had been wrongly convicted. It seemed clear that he'd been targeted due to poor investigative work and unreliable testimony. However, there was one major obstacle. One eyewitness remained steadfast in their belief that they had seen Joe commit the crime. No matter how much other evidence was presented, this one witness stood firm during every appeal and retrial. Every time Joe went back to court to fight for his freedom, this eyewitness would passionately testify against him. And every time the jury sided with the witness, ignoring all the new evidence that suggested Joe's innocence. It was heartbreaking. Despite overwhelming evidence suggesting Joe was not the perpetrator, he remained trapped behind bars simply because of one person's unwavering and possibly mistaken testimony. I can't recall if Joe ever got released in the end. But even if he did, by that point, he had already lost decades of his life. If anyone reading this happens to know the exact case, please share it. I'd love to read more about what eventually happened. Comment 1. I remember parts of this case too. There was a police officer involved. Let's call him Officer Briceño, who claimed he didn't pressure any witnesses during the investigation. He also said he had followed up on another suspect named Hubbard, who had confessed to the crime in a private conversation with a friend. Officer Briceño claimed that Hubbard's fingerprints didn't match those found at the crime scene or in the victim's car, which was part of why Hubbard wasn't pursued further. But here's the glaring problem. If the police were willing to clear Hubbard because his fingerprints didn't match, why didn't they apply the same standard to Joe? Joe had been convicted without any physical evidence tying him to the crime. Not even fingerprints. This was a clear case of tunnel vision by law enforcement. They latched onto a single theory early in the investigation, and ignored anything that didn't fit. Worse, they incentivized witnesses to testify against Joe, offering deals or benefits in exchange for statements. One of the key witnesses was even caught lying under oath. She had denied receiving anything in return for her testimony, but later it came out that she had been compensated. Despite this, the damage had already been done, and Joe remained in prison. Once his case reached the appeals stage, the burden of proof shifted unfairly. He not only had to prove he hadn't committed the crime, but he also needed to present entirely new evidence just to earn a new trial. It's a deeply broken system. Joe trusted that the truth would eventually set him free. But for over 30 years, the justice system failed him, and honestly, so did society. Two stories like this are absolutely heartbreaking. It's terrifying how often African Americans are wrongfully convicted or pinned for crimes they had nothing to do with. Before reading cases like this, I didn't fully grasp how bad the problem was. In some situations, it seems like all it takes for a black person to be accused of a crime is for them to have simply existed nearby at the time it happened. That alone is enough to make juries believe they're guilty, and for police officers to use them as scapegoats. It's horrifying how many innocent people have had their lives destroyed just because of the color of their skin and the biases of those in power. Story 6. I used to work as an assistant district attorney, often called an ADA. One particular case still sticks with me, and not for good reasons. We had built a strong case against an individual accused of serious crimes involving minors. The evidence against him was incredibly damning. He had recorded video footage of himself committing these offenses against his own daughter. It was one of the most horrifying cases I ever worked on. However, his defense attorney immediately began dragging out the legal proceedings. He filed delay after delay, using every legal maneuver possible to stall the case. This went on for over 2 years, stretching out the process far beyond what anyone would have expected. Eventually, the district attorney who had been overseeing the case retired. When the new district attorney took office, everything changed. He came in with a completely different agenda and immediately dropped all the pending charges we had been working on, including this one. Despite the overwhelming evidence we had gathered, it was devastating. Everyone on the legal team knew how strong our case was. We were certain we could have secured a conviction if we'd been allowed to move forward. But just like that, everything was dismissed. 1. That's absolutely unbelievable. Even if the new district attorney wasn't particularly interested in pursuing justice, which seems obvious from this story, you'd think he would have at least considered his own career. Cases like this are typically very high profile and can make or break a DA's public image. Winning such a case would have been an easy victory, something he could have touted as a success. 2. Assuming this took place in the United States, I can confirm that district attorneys are generally elected officials. That means their jobs often depend on how they're perceived by the public. A case involving such serious charges would almost certainly have been high profile, unless it was in an extremely large city where such cases are more common. Honestly, my gut tells me that there's something we're not hearing here. It's possible the original poster left out certain details that made the prosecution less straightforward than it seemed on the surface. I'm not sure what those details might be, but cases that look like slam dunks from the outside sometimes have hidden complications. I should also mention that legal systems in the United States can vary dramatically from place to place. One state's rules can be entirely different from another's, and sometimes even counties within the same state have wildly different practices. It's a chaotic system, built on layers of old laws and local traditions that don't always make sense when viewed from the outside. Story 7. Here's a lesser-known but incredibly powerful legal concept that many people aren't aware of: jury nullification. If you're ever selected for jury duty, it's generally advised to keep quiet about knowing what this term means, especially during the jury selection process. 1. Jury nullification happens when a jury decides to acquit a defendant, even if they are convinced beyond a reasonable doubt that the person is guilty according to the law. Essentially, the jury is saying, yes, this person broke the law, but we believe that convicting them would be unjust in this particular case. One of the most classic examples of jury nullification involves situations where a person commits a crime in response to extreme, prolonged abuse. For instance, if a woman kills her spouse after enduring years of domestic violence, a jury might sympathize with her situation and refuse to convict, despite clear evidence that she committed the act. Jury nullification is highly controversial. Some people believe juries should not have this power at all. According to this view, juries are there to apply the law, not to judge whether the law itself is fair or moral. Others argue that this power is essential, as it allows regular people to push back against laws they see as unjust. Interestingly, even though jury nullification is legal in the United States, and the Supreme Court has effectively upheld the jury's right to deliver any verdict they choose, jurors are almost never informed about this power. There is no requirement for courts to tell jurors that they can nullify, which means many people on juries have no idea this option even exists. Comment 2. It's important to clarify that jury nullification isn't technically a right in the sense that it's explicitly granted by law. Instead, it's a byproduct of two other key features of the American justice system. First, juries cannot be punished for delivering a so-called wrong verdict. If a jury finds someone not guilty, even in the face of overwhelming evidence, that decision cannot be reversed by the court. A judge can overturn a guilty verdict under certain circumstances, but they cannot change a not guilty verdict to guilty, no matter what. Second, the principle of double jeopardy ensures that a person cannot be tried twice for the same offense. Once a jury acquits someone, the state cannot bring that person back to court for the same charges again. Taken together, these two aspects of the legal system create a situation where juries can effectively nullify a law by refusing to convict. Whether intentional or not, this loophole is baked into the system. It's a fascinating and somewhat unsettling part of the justice process. In some cases, it allows juries to prevent injustices. In others, it can enable people to escape accountability for serious wrongdoing. Story 8. I'm not a prosecutor, but I grew up in a household where the legal system became a regular part of our lives, though not in any positive way. My parents were extremely abusive, so much so that when I was only 4 days old, Child Protective Services, CPS, had already tried to convince my mother to give me up for adoption. That was because they had received countless reports about the way my two older sisters were being treated at home. Unfortunately, despite the mountain of complaints, CPS wasn't successful at that time. I stayed with my parents, and the abuse continued. When I was around 6 years old, my parents were finally taken to court for child abuse and neglect. During the trial, my older sisters bravely gave testimony about what had been happening. CPS also presented their official reports, which included records of complaints from neighbors, teachers, doctors, and even our own grandmother. The evidence was overwhelming, but shockingly, the judge refused to take action against my parents. His reason: my mother hadn't confessed that my father had been abusive, and without that confession, he claimed there wasn't enough proof to hold them accountable. In the end, my parents were let go. We were sent into foster care afterward, though, and that changed the course of everything. From that point forward, CPS began removing every single child my parents had. In total, they lost custody of 6 children. Fast forward almost 20 years later. My mother was arrested once again, this time charged with felony child abuse involving 2 young girls, ages 10 and 11. Despite her history, she served only 3 months in jail because she convinced the court that her new husband was solely to blame for the abuse. What's even more infuriating is that as soon as she was released, CPS attempted to place those same girls back into her care. Their justification: her previous abuse cases were from a different state, so they claimed those incidents didn't count under local policies. Comment 1. CPS is, in my opinion, one of the most broken and dysfunctional systems in existence. I can't stand how people on the internet often have this idealized notion that calling CPS will automatically solve everything. Sadly, that's far from the truth, especially when it comes to teenagers. CPS has a terrible track record of making things worse instead of better, and they repeat their mistakes over and over again. I've had countless arguments with people online about this exact topic. For one, my local CPS once returned a young girl to the custody of her abuser, despite overwhelming evidence of wrongdoing. Second, there's a fundamental problem with how abuse is defined and handled by the system. People sometimes call CPS over normal parenting decisions, like grounding a teenager or enforcing strict house rules. CPS can destroy families in cases where no abuse occurred at all, and once you get their attention, it's nearly impossible to undo the damage they can cause. If a teenager, or even a well-meaning adult, makes an exaggerated or false report to CPS, it can have permanent consequences. Once CPS gets involved, it's like a runaway train. Meanwhile, some of the worst offenders, those parents who have multiple kids, live in dire conditions, and blatantly mistreat their children, often know exactly how to manipulate the system. They lie convincingly, stay calm under pressure, and use every loophole to keep their kids. They know what they can get away with, and they're skilled at dodging accountability. That's why, in my view, CPS consistently fails. No one will ever convince me otherwise. Story 9. This one is from when I was a kid, and it still frustrates me to this day. Our apartment was broken into, and whoever did it stole pretty much everything of value. They took all sorts of items, but the thing that hit me hardest was that they stole our PlayStation 1 and our television. I was around 6 years old at the time, and losing those things felt like the end of the world. The most upsetting part: we knew exactly who did it. It wasn't some mystery. We actually went to the person we suspected, and flat out asked them if they had taken our PlayStation and TV. I still remember that moment clearly. My family confronted them directly, but they denied everything, even though we had strong suspicions, and even confronted the thief. The police said they couldn't do anything about it. Their explanation? They didn't have enough evidence to pursue the case. To this day, it amazes me that you can know who committed a crime, even ask them about it, and still end up with no justice because of the lack of formal proof. Story 10. One of the most common reasons evidence doesn't make it into court is because of police mistakes. If the police mess up during their investigation, especially when they violate a suspect's constitutional rights, the evidence they gather can be suppressed and excluded from the trial. I've seen it happen too many times. I've watched confessions get thrown out. I've seen DNA evidence excluded. It's incredibly frustrating, especially when you have a victim who's counting on the legal system to hold their attacker accountable, but when the police don't follow the rules, everything falls apart. No matter how strong the evidence might be, if it was collected illegally or through coercion, it can't be used in court. That's the law, and it's always tough to tell a victim that their case has collapsed, not because there wasn't proof, but because the police violated protocol. It's heartbreaking, and it never gets any easier to explain. Story 11. I'm not in the legal profession, but I once had a run-in with corruption that left me furious. There was a city council official in my town who was blatantly taking bribes to approve local projects. I remember attending a meeting about a new sports center. I was there to argue on behalf of a much better qualified contractor who should have won the bid for the project. But it quickly became obvious that the official wasn't even listening. He had already made up his mind to award the project to a specific contractor. Afterward, I realized something strange. The official was carrying an umbrella with a very distinctive logo on it, one that I recognized immediately. That umbrella had been a promotional item from a photo shoot I had worked on. I knew exactly where it came from. It turned out that the promotional company behind the umbrella was owned by the same person who owned the contractor that won the project. Even more damning, that person was the council official's sister. There was no way the official could have gotten his hands on that specific umbrella unless he had a direct connection to the contractor. It was a glaring sign of corruption. Later on, I heard even more disturbing stories about the same official. He reportedly maneuvered his way into an office that had a direct view of the female changing rooms at a local swimming pool. He even had the opaque glass windows swapped out for clear-tinted ones. It's been over 20 years since I met that man, but I still despise him to this day.